Barry, Barry, Barry. Brings back good memories for you Lions fans out there. Speaking of the Lions, I was at a game recently, and I looked on the field, and there was no starting quarterback, no starting wide receiver, and their star defensive linemen weren't on the field. Why? Because it was a preseason game, not a regular season game, and they didn't want to put their best players out there to risk injury or to tip off an opponent in the future on what they might be running. Now, back in the world of Michigan landlord-tenant law, a lot of our clients have questions on what is a pretrial and how might that differ from a trial. So I want to spend a minute going over some details about a pretrial. First, and the most important thing is, you want to know which jurisdiction you're in, because a pretrial may mean something different from one city to another. At Paletz Law, we take pride in knowing which jurisdiction our client's in so we can best advise them accordingly, because each city or each judge within that same court may treat a pretrial differently. 2, a pretrial is often held in front of the magistrate, not the actual judge. And in most courts, a magistrate does not have the ability to make a final ruling. They just get some information about a case and then will set up for a hearing or trial in front of the judge. And third, and this is the most important part about a pretrial is when the court finds out about each party's claims and defenses. And if there's no dispute, if the tenant agrees to what you're asking for, if they agree to the rent owed, or they agree to vacate by a certain time, some courts may allow a consent agreement to happen at the pretrial. However, if the tenant disputes the claim, then what will usually happen is the court will allow the parties to exchange documents, which is notice of discovery, and parties can tell the judge if they want to file a motion or not. So again, that main argument's not going to happen at the pretrial. And then last, a pretrial is often when you first find out if someone's represented by an attorney or not, to get a general idea of their position. Our clients sometimes ask us why we didn't say X, Y, or Z at a pretrial. Well, there's 2 reasons for that. One, if we know that it's not the final or formal hearing and no decision is going to be made, just like a Lions preseason game, we're not going to waste our best arguments at the pretrial. We want to save them for the formal hearing or trial. And 2, quite frankly, if an attorney goes up there and tries to argue the whole case at a pretrial and there's not going to be a ruling, quite frankly, that makes them look like an amateur. I'm John Mione with Paletz Law. Thanks for watching. Make sure to like and subscribe so you get notices of future videos. I'll see you next time.